free speech, free exercise of religion, and freedom from government establishments of religion. All these freedoms are protected by the First Amendment. We could spend weeks and weeks talking about it, but we're going to hit the high points in just one module. We're going to talk about the general principles behind these freedoms, and we're going to look at some specific applications of these principles. So we're going to start talking about individual cases now. We're going to start meeting the people who've shaped our constitutional history. Native Americans who want to use peyote in religious rituals. Students who want to pray before a high school football game. And we'll start with a girl named Mary Beth. Mary Beth Tinker wore a black armband to school. She did this to express her opposition to the Vietnam War. School officials didn't approve. They suspended her. They said she could come back only if she agreed not to do it again. They wanted to control her expression. Can they do that? That's a First Amendment question. The First Amendment is one of the really big amendments. It's got 3 different important clauses, 1 about speech and 2 about religion. This week, we're going to talk about all 3, and we're going to start with the speech clause. What is the basic idea here? There are different theories out there, but something that was certainly present was the idea that free speech is essential to democracy. In a democracy, the people are supposed to govern. They're supposed to have the final say on policy. Indirectly, of course, but we the people are supposed to be the ultimate authority. We're supposed to govern ourselves. And we can't do a good job of that unless we have good information. Free speech is how that good information comes out. The idea here isn't that all opinions are equal. It isn't even that more opinions are better, necessarily. It's really that we don't trust the government to decide what speech should be heard. Here's Justice Stephen Breyer with more.
So you say you have to draw a line. You have to stick to the line. The line has to be that free speech is there not for people we like and not for people who have popular views. It's there for people we hate. It's there for the ones who are the most bigoted, terrible, awful people we can think of. And it's there for them, because if it isn't there for them, maybe someday it wouldn't be there for us. That's the argument. Well, that's the argument we pretty much accepted here.
We do trust the people. We trust that the marketplace of ideas will sort good ones from bad ones. So the First Amendment, like most of the Constitution, only applies when the government tries to restrain speech. What it says is that Congress shall make no law abridging the freedom of speech. But should it only apply to Congress? Could it be that the President can tell the FBI to shut up protesters? That wouldn't make much sense. So the Supreme Court has said it applies to the whole federal government. And, because of the 14th Amendment, remember, this free speech right is also a right that people can invoke against the states. That's why Mary Beth can raise it against school officials, who are state officials. But what does it mean? Free speech is a huge and complicated topic, because there are so many contexts in which free speech might be implicated. We've got to decide what counts as speech, for one thing. How about political contributions? Burning a flag or a draft card? Nude dance? Music? Abstract art? Yes, the Supreme Court says, to all those things. Speech ends up being defined very broadly. Anything that could in any way convey an idea or emotion can count as speech. So the armband counts. And not just political speech, but speech on any topic, because speech is an essential right. It defines who you are. Here's Justice Anthony Kennedy with more.
It's who you are. We define ourselves by what we say, by what we read, by what we think, by what we hear, by what we sing, by what we pray. This is who we are. This is our self-definition, and we define ourselves. The government does not define us.
Which again just makes things harder, because it increases the number of situations in which the government might restrain speech. The other thing that increases the number of situations where free speech issues come up is the growth of the government. We're going to see this again with the religion clauses of the First Amendment. But the general issue is this. It means one thing to say that the government can't restrain speech when the government is small, when it doesn't do much. If the government is, to oversimplify a bit, just the police, then we can see there may not be many situations where it makes sense to allow speech restrictions. And here you might think of the classic First Amendment speaker, the guy out on the street corner complaining about the government. The police shouldn't be able to shut him up. That's an easy First Amendment case. Here's Justice Breyer with more.
We start with a principle, and the principle is one we can pretty much agree on. The Constitution says Congress shall not abridge the freedom of speech. That means all government, not just Congress. But it doesn't say what the freedom of speech is, does it? So that's left to people to work out. Now, we started with what I think is the easiest principle, because it's the most widely accepted. That the worst thing you can do by way of abridgment is stop somebody from talking because you don't like what he says. Now, that's called his viewpoint, or it's called the content or the expression or the point of view. Now, it's easiest to say, well, certainly that's protected. But even there, you can find some borderline cases. And now we begin to move away from that and say, does it matter if he's in the Army? Does it matter if he's in high school? Does it matter if he's in grammar school? Does it matter what the subject is? Does it matter when it's said? Does it matter why it's said? Does it matter? Does it matter? Does it matter? And these are not just asked, which we were doing, to make it difficult for you. They were asked because that's what happens in a court that's concerned with free speech. We get one variation after another, and we have to decide what the principles are in these very different circumstances. And that isn't so easy, because the only thing we all agree upon is whatever the principle is in this case, it's going to be the same for all similar cases.
But what if the government is your employer? What if it's your school principal? As the government gets bigger, we get more citizen government interaction, and we get different kinds that aren't so easy to think about. And that's maybe the hardest thing about Mary Beth Tinker's case. The government isn't acting as a ruler here. It's not making and enforcing laws. It's educating children. So what kind of speech rights should public school students have? Well, it's kind of a hard question. On the one hand, public school officials are definitely the government. So one way of looking at Tinker is to say, school officials work for the state, just like police officers. So of course the First Amendment applies. But should it apply in exactly the same way? One thing that makes the government different, as far as the Constitution goes, is the kind of power it has. The power to lock you up. There's no private person out there who can tell you what to do in the way the police can. But there are private school principals, and they can definitely discipline students for speech they don't like. So another way to look at Tinker is to say, wait, this is nothing more than a private school principal can do. Restricting speech in some ways is just part of the job. School teachers grade people's tests. They give them good and bad grades based on what they say. They keep order in the classroom. They punish people for speaking out of turn. And what the Supreme Court ends up saying is, yes, students do have First Amendment rights, but we're going to have a different analysis of what violates those rights. If school officials have a reasonable fear of disruption, they can punish students for speech. This is also basically the rule that the court follows with other governmental institutions, with people who work for the government, or people who are in prison, or in the military. If speech will interfere with the institutional mission, it can be punished. Now, Mary Beth Tinker wins with this test, because there was no reasonable fear of disruption. But students or government employees don't always win. Sometimes there might be a reasonable fear of disruption. And later cases suggest that disruption isn't the only thing that can justify punishment. Interference with the school's educational mission includes more than disruption. It might include lewd or indecent speech. It might include speech that promotes illegal drug use. And this test also leaves open some hard questions. When is speech by students considered school speech? What if it's on the internet? The Supreme Court has split 5-4 in some of these more recent cases, which illustrates a more general point. There are easy cases and there are hard cases. The Supreme Court gets mostly hard cases, although often they look easier 10 or 20 years afterwards. But remember that there's a lot of easy constitutional law out there. Now, that said, the First Amendment is an area where we're going to see some hard ones. And one of the things that makes them hard is changes in the world, in particular, the role and the scope of government. And we'll see this in the next couple of classes too.